Welcome back, everybody, to the Law of Tort. We're moving on to the fourth major topic in this series of lessons today, talking about the talking about the concept, shall I say, of causation. This is going to be the next of our lessons in a series of lessons on the Law of Tort, talking about the concept of causation in this chapter. We're going to examine all the elements of causation, all the considerations that may be required to understand causation, before we then start looking at other torts that are not negligence. So we'll talk about employer and vicarious liability, for example, occupier's liability, intentional torts, nuisance, defamation, etc., etc., etc. Let's just refamiliarize ourselves one more time with the negligence equation. So when we think about negligence, when we think about what we need to do to show somebody has been negligent in the performance of a specific action, we have to think about these three considerations. We have to think firstly about the duty of care. We then have to think about whether or not that duty was breached, and in doing so consider things like the reasonable person test and the standard of care and all these different things. And then once that has been established, it must be shown that that breach had caused the damage that was incurred onto the claimant. Only when this can be shown will we find that there is liability in the case of negligence. So this series of lessons is going to focus on this third and final element of the concept of negligence. Now, theoretically, causation could be divided into two. We can talk about causation in fact as well as causation in law and remoteness, which we are going to do. Essentially, we're going to cover both of these things, but I've just sort of grouped them together under one umbrella, the umbrella of causation. So, unlike some of the other elements of tort we've been exploring, the concept of causation is not just related to the tort of negligence. It is in fact something that is important to consider for pretty much every other tort that we are examining. In fact, it is important to consider in a lot of other areas of the law as well. You will find causation in the criminal law. We've actually spoken about causation in the criminal law already on this channel. You'll also find causation and issues related to causation in the law of contracts. We will get to that in future lessons' time when we cover more lessons on contracts. So causation, essentially, is a concept that you will understand and would be very easy for you to understand given the expectation of the ordinary meaning of the word. In the context of negligence, causation essentially asks us to think about whether or not the breach of the duty of care, that failure to meet the standard of care that we've explored already, whether or not that was the cause of the damage done to the claimant. Essentially, so far, all that we have established is that there was a duty of care, that duty of care had been breached, and that there was some damage that was that had happened to a claimant, okay? But we haven't yet considered how the breach of duty causes that damage, because that is what's required, okay? You can have circumstances where there is an individual who has a duty of care, and then that individual fails to meet that duty of care, and then there is a breach of duty of care, and that a claimant has damage incurred onto them, but there wasn't a causation, that the breach and the damage were not causally linked, and as a result of which there is no claim. The person whose breach of duty was not liable for the damage to the claimant. Because why would that be fair, just, and reasonable to expect a defendant, just because they have breached the duty of care, to have to pay compensation for the damage done to a claimant if they were not the cause of said damage? There are multiple ways in which this is examined, the concept of causation, okay? And we will get to the ways in which this is examined in future lessons' time. Ultimately, causation is referring to this idea of the actions of one party being the cause of another. And there are multiple different considerations. There's things like material contribution to a particular illness or a particular damage that is caused. We'll consider something known as the Fairchild rule for specific cases of a specific kind of cancer, a specific kind of lung cancer as a result of asbestos, which sort of breaks the ordinary rationale of basic causation cases. And we will also talk about the idea of there being new intervening causes. So the idea of new things contributing to the damage that represents what are known as novus actus interveniens and may potentially absolve an individual from liability. So in the previous lesson, what we did was take an introduction to the concept of causation for the law of tort. And we just basically introduced the idea of causation. We noted that it is delineated between the idea of causation in fact as well as causation in law. And then we also explained the elements of causation as it related to the tort of negligence. Now in this video we're going to really examine what is arguably the most important part of the test for establishing causation between the breach of a duty of care and the damage that is established as a result of that breach. And this is something known as the but-for test. Like I mentioned, we looked briefly in the last lesson at the subject of causation, and essentially the next major topic in our series on the law of tort. We're going to be covering causation for the next few lessons. This lesson is examining, as I've mentioned, the first major principle of the concept of causation, which is the but-for test. Now, the but-for test is quite easy to understand, really. Essentially, the but-for test is a hypothetical test, and it is a hypothetical experiment, if you will, a thought experiment that you have to do in consideration of the facts of a particular case. And it essentially asks us to ask the question, really, the impact and the extent to which the actions that were ascribed to the defendant were impactful to such an extent as to be able to cause the tortious event that leads to the damage to the claimant. So it assumes that, first of all, we're assuming that there is a breach of a duty of care. And the but-for test simply asks us to consider the question, but for the actions of the defendant, would the damage have occurred? That's essentially the gist of the but-for test in terms of its basic descriptive elements. We're essentially asking the question, if the actions of the defendant had not have happened, if the defendant had not have breached a duty of care, would the damage that was caused to the claimant still have occurred? If the answer is no, if the damage didn't and wouldn't have occurred if there wasn't a breach of a duty of care, then this would satisfy the but-for test and establish causation in fact. If it would be the case, if it's the case that even if the defendant did not breach a duty of care, the damage that was caused to a claimant would have still had taken place, this would suggest that there were other factors which contributed to the cause of the damage, and so as a result of which we would not satisfy causation in fact as a result. Now, to illustrate this point, let's have a look at a piece of case law. We can talk about the 1969 case of Burnett and Chelsea Hospital. Now, this was a case where there were a number of claimants who had brought a claim on the basis that they had become ill or as the result of drinking some tea. It was later found that they had suffered from arsenic poisoning, leading at least one of them to have died. In the process, they went to the hospital, but they were turned away. So they had become ill as a result of drinking some tea. As it turned out, there was arsenic in the tea, which is obviously not very good. It's a toxic to humans, at least arsenic is. And one of them dies, and when we talk about what had happened in terms of the events, they had gone to the hospital complaining about the fact that they were ill as the result of drinking this tea, and the hospital had said, well, we're going to turn you away for whatever reason. Maybe they didn't believe that the illness was sufficiently serious to merit being hospitalized, or whether or not they had enough space to hospitalize these people. Regardless, whatever was the reason, the hospital had turned them away. The question here was whether or not the failure on the part of the doctors to see the claimants had been the cause of the death. So the question here is essentially they had gone to the hospital, they had been turned away, and one of them died. Okay. Now the question here is for causation to be established. So, but for the turning of the claimants away from the hospital, would the damage still have occurred? So essentially, if it wasn't for the fact that the hospital had turned them away, would the claimant have still died? That is the question that we're asking here. So was it the failure of the doctors to see the claimant, was that the cause of the death? If they had have not been turned away, would they have still died? It was found that on the balance of probabilities, and owing to the amount of arsenic that was consumed and the severity of the poisoning, it would have been very likely that the patient would have died regardless of treatment that a doctor had given them. So even if they had gone to the hospital, they had been hospitalized, a doctor would have seen them, even if the doctor would have known that it was arsenic poisoning and prescribed the relevant treatments, it is still, on the balance of probabilities, it was found that they would have still probably died as a result of the consumption of this poison. And so, in application of the but-for test, the cause of the death was not the doctors failing to see the patients. It was not the doctors negligently failing to see the patients. It was the arsenic poisoning that would have caused the death, regardless of even if the doctors had not have been negligent or had not have breached a standard of care. Where there is a question of causation, there is an evidential burden that is going to be placed on the claimant to prove that the actions of the defendant had been the cause of the harm, and that but for the actions of the defendant, the claimant would have not suffered any kind of damage. So in terms of the evidential burden, the burden of responsibility, the burden of proof for causation questions, that rests solely on that of the claimant. And that makes sense for a basic understanding of natural justice, given the fact that you wouldn't assume that the actions of a defendant caused the damage to the claimant, and then it is up for the defendant to rebut that assumption. It is in the sense that you are proving a positive rather than trying to disprove a negative. Welcome back, everybody, to the Law of Tort. We're continuing in this video talking about the concept of causation, examining this idea of a loss of a chance claim. We'll talk about loss of a chance in broad detail in this video before starting to talk about some of the exceptions or some of the alterations of the basic bog standard but-for test, which refers to things like the idea of material contribution and even the Fairchild exception or the Fairchild rule. So, the previous lesson, we spent some time examining what the but-for test actually was when it comes to causation. The but-for test is the traditional examination for the establishment of a causation in fact claim. Essentially, it is asking the question that, assuming in the case of a tortious claim, there is a duty of care and then there's a breach of that duty of care, did the breach cause the damage in question? And essentially, in wording this in relation to the concept of the but-for test, it is asking us the question of, but for the actions of the defendant, but for the breach of the duty of care, would the damage still have occurred? If the answer is yes, if the damage would have occurred regardless of whether or not the defendant had breached the duty of care, then you can claim that it was not the breach of the duty of care which was the cause of the damage. If the damage was not have been caused as a result of the breach of the duty of care, then you can argue that it was the damage that was that it was the breach of the duty of care that had caused the damage in question, and so we have established causation in fact. This lesson is going to spend some time examining another application of a legal principle, this being the idea of a loss of a chance claim. Now, previously, we spoke about the evidential burden which is placed on the claimant. So essentially what the claimant has to do is prove, on the balance of probabilities, because we're talking about civil claims, that the actions of the defendant were the cause of the damage. Okay, so the burden of proof for the establishment of causation is one that relates to the claimant. The claimant has to prove that it was the actions, the negligence, the breach of a duty of care of the defendant. This was the cause of the damage that the claimant suffered, or at least the claimant's client, assuming that we're talking about a situation in court. But this is what the evidential burden looks like. That's where the evidential standard essentially relates. This is known as the all or nothing approach. Essentially, the claimant has to prove that, but for the actions of the defendant, on the balance of probability, the damage would not have occurred. So it's a particularly high standard. You have to basically essentially invite people into a hypothetical world where the breach of a duty of care had not had happened, and examine what was the factual circumstances had the breach of a duty of care not had happened. If that, in that hypothetical world, in that hypothetical possible world, the claimant still suffered damage, then you would conclude, therefore, that it was not the actions of the defendant that caused the damage. It was some other thing. Or if you look in the hypothetical world where there was not a breach of duty of care, and then it turns out that the claimant was fine, there was no damage, there was no injury at all, then you can conclude quite safely that it was the case that the defendant's actions in breaching their duty of care had led to and caused the damage to the claimant. All of this is an evidential approach and an evidential standard and an evidential burden which is placed on the claimant to prove, okay? Loss of a chance claims are slightly different, though, because what loss of a chance claims have sought to do is try and alter and modify the issue of the but-for test by suggesting that claims can be brought on the basis of that the actions of a defendant not necessarily cause the event to take place, but would bring about a situation where the claimant is then deprived of the possibility of avoiding damage. So, essentially what this is doing is we're not talking here about there being a breach of a duty of care and that breach in and of itself causes some damage. What we're talking about here is that there is a breach of a duty of care, but the breach of a duty of care essentially establishes a situation, brings about a set of circumstances which then deprives the claimant of their ability to avoid some kind of damage. So it is not the breach of the duty of care directly causing the damage. It is the breach of a duty of care essentially establishing a situation where the claimant, even if they wanted to avoid any kind of damage, could not do so. Okay, that's what a loss of a chance does. It essentially it takes away from the claimant the chance to be able to avoid a damaging situation. They're losing that chance, hence the name. Courts have been very, 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 very strict in their approach to loss of a chance claims. Of course, whenever there is a potentiality for a new claim or a new method of making a claim to be brought to a case and to be brought into the law of tort, courts have always been particularly reticent of allowing them to be the case, owing to the policy implications, the potential floodgates implications of allowing a new method of litigation, which could then essentially bring about a whole host of new cases of litigation. So in 1987, we can get an example of how this works in the case of Hodson and Berkshire AHA. This was a case which involved a young boy who had injured his hip as a result of a fall. So he fell over, essentially, and then he had a hip injury. The boy was subsequently, as a result of this injury and the fall, taken to the hospital, where he had been negligently misdiagnosed by the doctor. It was only a few days later when they returned to the hospital, or I believe they maybe stayed in hospital. Essentially, it was only a few days later when the correct diagnosis was made. The mistakenly misdiagnosed original diagnosis was corrected and rectified, and a correct diagnosis was made. Years later, then, the claimant would develop a pain and a disability on the basis of what he claimed to be the failure to properly diagnose the hip injury in the first instance. So this negligent misdiagnosis originally was argued to have been the cause, shall I say, of the disability and the development of a pain. At trial, medical evidence was presented which suggested that had the hospital had made the correct diagnosis originally, there would have been a 25% chance that the boy would have made a full recovery. Okay, so medical evidence at trial actually did support, to an extent, some of the claims that were made by the claimant. That if there had not have been this delay in the correct diagnosis of a few days, and they had been diagnosed correctly originally, then there was a chance, only a 25% chance, but a chance that there would have been a full recovery made by the boy, and this whole disability and this whole pain that was developed would never have happened. So what does this do? Well, this falls below the standard for a but-for test of causation, given the fact that we have to prove on the balance of probabilities, which is more than 50%, that the cause would have not have happened. Sorry, the damage would not have happened if it hadn't have been for the medical misdiagnosis. And so as a result of that, in application of the but-for test, this didn't result in a claim. Okay, there was no claim for the claimant, despite the fact that the hospital did concede that the failure to properly diagnose the claimant originally was the result of negligence. So even though it was conceded by the hospital that there was a negligent misdiagnosis originally, the fact that there was so little of a chance for the boy to make a full recovery meant that the courts were not going to allow this claim to have been made. In 2005, we get the case of Gregg and Scott, and this was also a case which involves medical misdiagnosis and medical negligence at a hospital. The defendant in this case was a doctor and again had made a misdiagnosis on the basis of a lump which was found under the arm of a claimant. They concluded that the lump was harmless, and as a result, there was nothing to worry about. And so don't get worried about it. Just leave it, and it will go away. However, this was not the case. The lump was not harmless. A few months later, it would later transpire that the lump was a cancer, which at this point had spread to other parts of the body, making it much more difficult for the claimant to make a recovery. Essentially, it was held on the basis of the medical evidence in the case that had the doctor made the correct diagnosis at the time, there would have been a 45% chance of survival. A 45% chance that the claimant would have made a full and speedy recovery. Okay, so this is still less than half. So even if there had have been a correct diagnosis and the doctor had said, look, that lump is serious, we're going to go and have more tests and we're going to get a proper diagnosis of what it is, and we'll treat it accordingly, there would have been a 45% chance of survival. Again, this falls below the 50% balance of probabilities standard for the but-for test. Now, what the claimants wanted to show was that a loss of a chance meant there ought to be liability. Okay, the House of Lords again would reject this perspective. It could not be shown in this case that the chances of survival had been greater than 50%, that the claim itself would have been greater than 50% on balance of probabilities. And so the courts have been always reticent of the fact that if you have a below than 50% chance of the event had not have happened, essentially the negligence had not have caused the damage, then the courts have always been very reluctant to allow liability in those cases. In this lesson, we are continuing our discussion on causation, and we're going to discuss an element of causation known as material contribution. The elements of material contribution, as well as some of the case law that illustrates the point relating to material contribution and the ways in which material contribution actually causes some problems or at least the problems that are attempted to be solved by material contribution as an issue. The previous lesson talked about the idea of loss of a chance claims in the law of causation, specifically in relation to the law of tort. We noted that, and illustrated using a couple of examples from the case law, that courts have often been quite reluctant to allow proof of causation in fact on the basis of loss of a chance claims. We're going to talk about the concept of language such as material contribution to damage, though, as being caused by a defendant in this lesson, as a way of being able to understand the process by which some claims can be successful in this particular area. So, there are some cases where damage that is caused to the claimant is not one particular thing. We've been focusing really on quite simple to understand causation issues, where an event happens, and but for that event happening, there wouldn't have been damage done to the claimant. So therefore, the damage that was caused to the claimant was caused by this event. And so the person who did the event, i.e. who breached their duty of care in allowing the event to take place, for example, is liable in negligence, for example. Instead, however, it is represented as an accumulation of damage, which has potentially a number of different causes. There are quite a few cases that do involve there being this idea of there being some kind of accumulation of harm, whereby the actual cause of the harm is not a single thing that happens at a single point in time, but maybe is a combination of things that take place over a long period of time. If there are multiple different causes, each of these causes having a cumulative effect, then the damage from a defendant can be said to represent a material contribution to the harm, rather than necessarily being representative as being the only thing that causes the harm, i.e. application of the but-for test. An illustration of this is the 1956 case of Bonington Castings versus Wardlaw. In this case, the claimant had worked in the workshop of the defendant. The work of the claimant involved the inhalation of dust, the accumulation of which would result in the claimant suffering from a lung disease as a result of inhaling from dust. And it was showed on the basis of medical evidence that the accumulation of the dust led to the disease, and the severity of the disease was dependent on the accumulation of the dust that was inhaled, i.e., the more dust that was inhaled, the worse the disease got. And it was also found that some of this was the result of negligence on the part of the defendant, but some was also unavoidable. There's no liability necessarily on the part of a defendant for owning a workshop that a claimant voluntarily works for that has certain dangers that are attached to it. It is not that really gains negligence claims. Where negligence claims come from is where there is a duty of care, but then that duty of care is breached. On a traditional reading of the but-for test, the claimant would actually be unable to satisfy that because the damage for the negligence of the defendant, the damage would not have occurred. So if you note here that there's essentially an accumulation of dust as a result of working at this workshop for a long period of time. But the accumulation of this dust, the inhalation of this dust, would have taken place at various different levels had there not been any negligence. So there was an amount of dust that was caused by negligence, but there was also an amount that was caused as a result of non-negligent action. So if we were to apply the but-for test, i.e. but for the negligence of the defendant, would the damage have still occurred? Well, maybe to a lesser extent, but yes, there would have still been damage. There would have still been this lung disease because some of the accumulation of the dust and the inhalation of the dust was the result of non-negligent action. So we can't satisfy the but-for test. But the House of Lords didn't say that there was no claim. They concluded that negligence on the part of the defendant had been a, quote, material contribution to the damage, and as such meant that a claim could therefore be made. A similar thing takes place in 1973 when we have the case of McGee versus the National Coal Board. This case, the claimant developed a skin condition on the basis of exposure to brick dust when they were working in the work of a brick kiln. Now, there was going to naturally have been an exposure to the brick dust in a similar way as the previous case was an exposure to the dust from the workshop. But there was also negligence on the part of the defendant because they had failed to provide washing facilities at the end of the day, which exacerbated the skin condition. The issue for the claimant was that they had been exposed to brick dust throughout the day, and the failure to provide the washing facilities was where the negligence arose. So the exposure to the dust throughout the day was non-negligent. Okay, there was no duty of care to keep the claimant away from the brick dust. They were working in a brick kiln. It was obviously going to happen that they were going to be exposed to some brick dust. The negligence came in their failure to provide some kind of washing facilities to get them to be clean after the work had been done. Now, the claimant argued or alleged that it was this failure to provide washing facilities that led to the skin condition, and it wasn't the non-negligent action of requiring the claimant to work in the brick kiln. That was not part of the consideration. But despite the fact that the claimant could not show the but-for test, they could not prove on the basis of a but-for test that the failure of the defendant to provide washing facilities would have not led to the skin condition, the court still ruled in favour of the claimant. So again, on a traditional but-for application, we ask the question, but for the actions of the defendant, would the negligence have still taken place? And the claimant cannot prove that it wouldn't have taken place because they were still exposed to the brick dust, and so it was likely that they probably would have still had a skin condition. So they had to find a different way, and this was on the basis of material contribution. Showing that the condition was developed as the result of the failure to provide adequate facilities was impossible. To show that there was, and to therefore satisfy the but-for test, i.e. it was this negligent action that caused this skin condition, not all of the other times I've been exposed to the brick dust that was not the result of negligent action. But it was held that where such evidential standards are impossible to meet, it was best to find in favour of the party who suffered damage. And so the result here is that the default here consisted not in adding a material quantity of accumulation to injurious particles, but the failure to take a step which materially increased the risk. So because there was a material increase in the risk of damage that was caused, then this is really where a claim can be made on the basis of material contribution. In this video, what we're going to do is continue talking about causation for the law of torts, focusing on this idea known as the Fairchild rule, which represents something of an exception to this idea of material contribution in establishing causation. Now, this is one of the main issues relating to causation and material contribution, because it is a very limited rule that is applied. It is a rule that is limited to only the issue, at least in terms of the facts of the case, the issue of asbestos cases. And I mean, it's in all likelihood possible for there to be similar circumstances and factual circumstances that would actually merit application of the Fairchild rule, but for the most part, we're talking about asbestos cases in this regard. So as a recap, though, the previous lesson talked about the case of Bonington, Castings and Wardlaw, and also the case of McGee versus the National Coal Board. And we noted that while it was the case that it was difficult, or in some cases even impossible, to show that the damage that was caused specifically by negligent action, the courts held that that doesn't mean that there can be no claim, because there could be a claim on the basis of material contribution, and the defendant was therefore liable for that instead. The case of McGee was the case involving the exposure to brick dust, which led to a skin condition. The exposure to brick dust was the result, firstly, of a failure on the part of the defendant, a negligent failure on the part of the defendant to provide adequate washing facilities, but also just the result of the day-to-day work of working in a brick kiln, which had not been the result of negligent action. So you sort of have exposure to brick dust caused both by negligent and non-negligent action, and the defendant develops a skin condition, which then is of course the damage that is being claimed for. Now, given this circumstance, the defendant cannot show in any way that but for the negligent action, the skin condition would not have taken place. They cannot show where the skin condition came from, because it was an exposure from brick dust that was both negligent and non-negligent alike. As such, we can think about this as material contribution. Now, things get a little bit more complicated when we think about asbestos cases. And the reason for this is because asbestos is firstly a toxic material that used to be used quite a lot in insulation. It is definitely no longer used in insulation, and in fact quite a serious issue if you find asbestos in your house. One of the diseases that is caused through the inhalation of asbestos is a very rare and very aggressive form of lung cancer called mesothelioma. It has actually, I believe, a 2% survival rate in terms of if you catch mesothelioma. The issue for this is the issue of causation, because the development of this lung cancer is not something which is the result of a gradual accumulation or inhalation of asbestos fibers. It's not like the case of Bonington Castings, for example, where there was a direct correlation between the amount of dust that was inhaled and the severity of the lung condition that was suffered. When we talk about mesothelioma and asbestos cases, in fact, one fiber could cause mesothelioma. Equally, the inhalation of quite a lot of asbestos could also cause mesothelioma. Because it is a form of cancer, it obviously results in the mutation of a cell within the lung, which then, of course, develops into a cancer. So it's not as simple and clear-cut as more asbestos equals higher, more cancer, essentially, or lower survival rate. In fact, one asbestos fiber could cause mesothelioma, and it could also cause mesothelioma either cause it to develop quite early on, or it could develop years and years and years and years after the inhalation of mesothelioma. In fact, as a sort of a personal anecdote, my granddad died of mesothelioma from working, we believe, in a printer's. And This was 30, 40 years maybe after he had left that job, and so and then developed it at a later age in his 70s. So this is a particularly nasty and aggressive form of cancer that isn't as clear cut when it comes to material contribution as the previous cases stated. And so we have the case of Fairchild versus Glenhaven Funeral Services. This case, the claimants had been negligently exposed to asbestos fibres. Remember, there still has to be a negligent exposure. There still has to be some kind of negligence here. This was done over the course of numerous different employments, and as a result, they developed this rare form of lung cancer. The main issue is that it was not known to the extent to which a single fibre of asbestos could cause mesothelioma, or the extent of accumulation into the cause. And it seemed likely impossible that a single fibre could develop the disease, just as much as the slow accumulation of the fibres could leave a person without the disease. So you could go through and inhale quite a lot of asbestos, and you might be absolutely fine. But you could equally inhale one fibre and get mesothelioma. It is quite random in this regard. So this is not the same, as you can imagine, to the Bonington castings or the McGee case, where there is a slow, gradual development of the illness as a result of a slow accumulation of the dust particles. The Court of Appeal would reject the claims on the basis of the ordinary approaches to causation. But what the House of Lords did was overturn this and create a novel ruling, a novel exception to some of the basic causation principles because of the nature of this illness. They rejected, firstly, the ordinary but-for test on the basis that, for policy considerations, the defendants ought to be liable on the basis that they had created a material increase of risk to the various claimants, rather than trying to show but for the fibres in question, there would not have been mesothelioma. Because that is absolutely an impossible feat to try and show. If we were to apply the but-for test, how could you even possibly know which asbestos fibre A was the cause of the illness, and where that asbestos fibre came from? Did it come from employment A? Did it come from employment B or employment C? Again, all of which is impossible to know. So the application of the but-for test would be impossible here. And so the result of this was, on the basis of a material increase of risk to the various claimants, there was joint liability on the basis of this. Since Fairchild, there have been other cases, one which sought the apportion to damages to various employees. This was the case of Barker and Corpus UK. However, this was overturned by the statute in the passage of the Compensation Act of that same year.